Do you spend part of the year in one state and the rest in another? If you're nodding your head, then you're probably one of those snowbirds. And guess what? Your estate plan needs to reflect that too. Today, I'm going to walk you through some smart strategies for managing property in multiple states so you can protect what you've worked for no matter where you are. Hey, I'm Laura Croft from Timeless Estate Planning. If you're all about simplifying your estate planning and protecting your assets, go ahead and hit that subscribe button so you don't miss out on any of our helpful tips. Now, today's question is super important. How do you manage your estate plan when you've got property in two different states? And what can you do to avoid a big mess when the time comes? Let's start by talking about the problem. Owning property in more than one state can lead to multiple probate proceedings after you pass away. And trust me, that means more time, more expenses, and a whole lot of extra hassle for your loved ones. The first thing you need to think about is setting up a revocable living trust. When you transfer your properties, whether it's your cozy little cabin up north or that sunny condo down south, into the trust, you can avoid probate in both states. That means your successor trustee can take care of everything smoothly without having to go through the court process. It's a game changer for snowbirds who want to keep things simple. Next up, let's talk about something super important. Your state of domicile. That's just a fancy way of saying your legal residence. Why does this matter? Well, it impacts things like state income taxes, estate taxes, and all sorts of other legal stuff. So make sure you're consistent with your records, voter registration, driver's license, tax filings. All of that should be in your primary state to avoid confusion later on. Now, you've got your trust in place, but what about your actual estate planning documents? You've got to make sure that things like your will, power of attorney, and healthcare directives are valid and recognized in both states. Some states have their own requirements, so what's legal in one might not be in the other. Better safe than sorry, right? Here's another tip. Review your property titles. The way property is titled, whether it's joint ownership, tenancy by the entirety, or community property laws, can vary by state. These titles will affect how your assets are transferred when you're no longer around, so make sure everything is aligned properly with your estate plan. And last, but definitely not least, get yourself an estate planning attorney who knows their stuff when it comes to multi-state planning. We can help you create a strategy that minimizes taxes, avoids unnecessary court proceedings, and gives you peace of mind no matter where you're living. So, if you're a snowbird and ready to simplify your estate planning, give us a shout at Timeless Estate Planning. We're here to make sure everything is set up right for you, wherever you call home. If this was helpful, give it a thumbs up, subscribe for more, and leave your questions in the comments below. Thanks for watching.